अयोध्या में श्री राम जन्मभूमि पर 500 साल के संघर्ष के बाद बनने जा रहा श्री राम का भव्य दिव्य मंदिर और इस सब के बीच 134 साल का लंबा विधिक संघर्ष, शायद देश के या विश्व के इतिहास में सबसे लंबा विधिक संघर्ष हिंदू समाज को इतना लड़ना पड़ा और आखिर सुप्रीम कोर्ट में ये तय हुआ कि रामलला विराजमान ही श्री राम जन्मभूमि के असली उनके अधिकारी हैं। वो पहले भी थे, ये शाश्वत सत्य है, एक बार फिर स्थापित हुआ है, सनातन सत्य है, फिर स्थापित हुआ है कि श्री राम जन्मभूमि उन्हीं की है, उन्हीं की थी और रहेगी। लेकिन इस सब के बीच श्री रामलला विराजमान का एक केस अदालत में, शीर्ष अदालत में खास तौर पे रामलला के जिन सखाओं ने लड़ा उनमें से एक श्री पीवी योगेश्वरन इस वक्त हमारे साथ हैं। पीवी योगेश्वरन जी, बहुत बहुत स्वागत है। बड़ा मुश्किल मुझे लगता रहा होगा जब खास तौर पे 40 दिनों के अंदर जब रोज़ डेली हियरिंग होती थी तो आपसे कहा गया कि उन 40 दिनों में आपने एस्टैब्लिश कर देना। बातें पहले भी हुई, एफिडेविट बहुत सारे आए, पर वहाँ अल्टीमेटली आपको एस्टैब्लिश करना था। कौन से ऐसे मेजर पॉइंट्स थे जब आप कह पाए और जिसको कोर्ट ने माना और अल्टीमेटली कोर्ट कन्विंस हुआ और श्री राम को उन जन्मभूमि पर वापस विराजमान होने का हक मिला?
ये तो लीगल केस है। लीगल केस तो सारा डॉक्यूमेंट्री के ऊपर, डॉक्यूमेंट्री के आधार पे होते हैं केस। ये सिर्फ फेथ का नहीं है, सिर्फ फेथ इसका मतलब ही नहीं है। फेथ एक पार्ट है लेकिन फेथ ही नहीं है। हम ये स्थापित कर दिया कोर्ट में, ये ज़मीन शुरू से फ्रॉम टाइम इमेमोरियल, इसके मतलब किसी को भी मालूम नहीं है वो कब से वो उधर मंदिर था। एंड दैट टेम्पल वॉज बिलीव्ड टू बी द प्लेस ऑफ राम्स बर्थ प्लेस. So it is very easy for us to establish that the place is birthplace of Ram temple. And Muslims have filed an affidavit and made a statement before the court. They are not disputing that Ayodhya is the place where Ram was born. And so therefore it is established Ayodhya is the place where Ram was born. The only dispute is whether this is the place where Ram was born. But the Muslim also says it is not the place, but the place above or besides 100 meters. The place besides the 100 meters is the place where Ram was born. That was the Muslims' case. So it was very easy for us. It is not very difficult for us to establish the case. Only the difficulty was it is prolonged long because we filed the suit in 1951. In 1951, January 16th, we filed the suit. As soon as we kept the Ramlala inside the premises, the entire suit property is 1468 square yard. It is very small property. And in that property, there are two divisions. One is constructed place, where the mosque-like structure was constructed, which was demolished in 1528 by Babur. There was a massive temple. That temple was destroyed by Babur in 1528 and he constructed a mosque-like structure. When he destroyed the temple, we took the idols and we kept it ourselves, and we don't know what is on the evidence to produce when we kept inside, but it is on evidence that consistently we are worshipping that place as a Ram's birthplace, and the idol was there. And when idol was kept outside the premises, but inside the premises, but outside the building, and on December 22nd night we kept the idol inside. Immediately on the morning, police registered the complaint against the people and FIR was lodged. And the next day, the entire premises was sealed. And 145 proceedings, 144 proceedings were initiated. And nobody was allowed to go inside except the pujari to perform the puja. And immediately, one advocate, one president of the panchayat, he was appointed as a receiver and he has taken charge and the puja was performance. And till today, till the date, the puja was continuously performed. Only in 1982, that lock was put and the lock was opened. And till then also the puja was performed. So therefore, it was very easy for us to establish that puja was performed from the very same place. And it was difficult for the Muslims to disprove that. Because Muslims' case is very, very weak. They didn't file the case immediately. We entered into the premises, according to us, we entered into the premises in December 22nd, 1950. And they they filed the suit in 1961, before 4 years to complete the 12 years, because they were not really interested in that mosque. Because they have more than 500 mosques in the Ayodhya, and hardly 2000 Muslims were there. 500 mosques for 2000 Muslims, it is sufficient to perform namaz. So therefore they are not really and genuinely interested in the mosque. It was the handwork of some outsiders who instigated to file the suit. So that suit was not very strong suit, and it is very easy case for a Hindus.
हम जब कहते हैं लोगों को बड़ा अचरज होता है जो शायद लीगल सिस्टम को नहीं समझते हैं, इस केस में रामलला विराजमान जो साक्षात उपस्थित नहीं है पर केस वही लड़ रहे हैं और उनको विधिक माना भी गया। ये ज़रा कॉन्सेप्ट समझाइए आम जनता के लिए, कैसे रामलला विराजमान स्वयं लड़ रहे थे और उनके सखा उनका पक्ष रख रहे थे। ये बड़ा इंटरेस्टिंग है जानना।
ये देखो, हमारा देश में तो भगवान को हम सब मानते हैं। हमारा देश में भगवान का भोजन करते हैं, भगवान को आदमी के तरफ, भगवान का दोस्त के तरफ, भगवान का गुरु के तरफ हम मानते हैं। भगवान सुबह उठते हैं, सुप्रभातम करके भगवान का उठते हैं और भगवान का भोजन करते हैं, फिर भगवान का रात को सुलाते हैं। सो ऑल दीज थिंग्स वी कंसिडर्ड गॉड एज आवर पर्सन, and we dedicated, not only that, we dedicated property to the God, and that is called endowment to the God. But when Britishers came to India, they find इनको थोड़ा अजीब लग रहे हैं, ये कैसे भगवान का प्रॉपर्टी कैसे हो सकते हैं, इसलिए they find it very difficult to understand this concept. Then later it is the judicially evolved concept. The Bhagavan, the deity, will become a juristic person. Matlab, it is an artificial person. So therefore juristic person can perform all acts. The juristic person can own the property. The juristic person can donate the property. So therefore, in order to protect the property, the idol, the deity, Bhagavan का juristic person करके वो प्रॉपर्टी पालन करते हैं। इसलिए वो भगवान इनका प्रॉपर्टी का सेफ करने के लिए इन्होंने खुद लड़ाई किया इसी केस में। And it is not the first case where the deity became the plaintiff. There are so many cases. The law has developed that deity is a juristic person. The law is well developed, and it is the one of the case where the law is developed and the deity filed the suit to protect his own property, his own temple.
जब आपने एक टाइम इमेमोरियल का कॉन्सेप्ट आपने कहा और आपने राजा विक्रमादित्य के समय से इतना साक्ष्य, सब कुछ, इतना एविडेंस होने के बाद भी मुस्लिम पक्ष ने जितने अड़ंगे लगाए, आपने ये भी कहा कि बहुत इजी था हम लोगों के लिए एस्टैब्लिश करना, पर फिर भी 134 साल लग गए निचली अदालत से लेकर के सुप्रीम कोर्ट में आने तक और अल्टीमेट निर्णय होने तक। वो कैसे हुआ? क्या इसको मानते अपने जुडिशियल सिस्टम की कुछ वीकनेस है या चला कैसे वो बार बार अड़ंगे आए?
We have been worshipping that place from time immemorial. Time immemorial in a legal sense, it is 100 years, only 100 years. And there is a temple is existing and the people are believing that this is the place where Ram born. You don't prove the belief, but you can prove the existence of belief. So we have proved the existence of the belief that the people have been worshipping that place as the birthplace of Ram. And this has been continuously proving. And we proved it. And Muslims have a weakness. They don't have any case at all. Because the mosque cannot be a except the mosque cannot be a legal property except it is declared as a waqf property. Because waqf means it is the property dedicated to Allah. So the mosque is necessarily and it should be dedicated to Allah. And it is a temple property, cannot be dedicated to Allah. It is in Islamic sense, it is an haram. So therefore they find it very difficult to establish this is a mosque in a legal sense, in an Islamic sense. The court also find it very difficult to accept it. However, the court rendered the finding that this is not a, High Court has rendered the finding, this is not a mosque in according to Islamic jurisprudence. However, the Muslims believed this as a mosque and they performed namaz. Therefore, it is called mosque. So, therefore, I would tell you, we have not won the case by belief. It is Muslims, they pleaded that by the belief, they tried to establish that that is a mosque. So Hindus have a legal right, and we won even without proving the belief that we have a legal document, because Kasara Girdavari is in our favor. Entire area belongs to Ram. This was been fully, completely established, because you don't trace the title for the temple. You can trace the title for the property which can be dedicated to the god. But temple is there, you need not to trace the title, except the continuous worship is proved, then it is called a temple.
एक और बड़ा इंटरेस्टिंग पॉइंट था, आपने कुछ देर पहले बातचीत में कहा कि मीडिएशन में सिर्फ आप गए थे और काफ़ी ऐसी सारी चीज़ें थी जो मीडिएशन में आपने समझाने की कोशिश की, लेकिन वो फॉर सम और द अदर रीज़न वो सच को देखते हुए भी उसको स्वीकार नहीं कर रहे थे, एक्सेप्ट नहीं कर रहे थे. सो इस पूरे ट्रायल में सुप्रीम कोर्ट में जब आप थे, ऐसा कौन सा मेजर टर्निंग पॉइंट था जब आपको लगा कि ये केस तो अब हमारा है? फैक्ट्स आपके पास थे, आपको पता था, लेकिन सुप्रीम कोर्ट में केस चलते हुए वो डिफीट हो रहे हैं, ऐसा कौन सा टर्निंग पॉइंट था जब आपको लगा?
फॉर द डीटी, द नेक्स्ट फ्रेंड विल फाइल द सूट, or any person can file the suit. You are a devotee, and in order to protect my deity, my temple, I can file the suit. Only you have to seek permission from the court that I have to file the suit on behalf of the deity, and the court will give permission and you will file the suit. But it is not in the case of mosque. Any person cannot file the suit on behalf of mosque. Only Mutawalli has to file the suit on behalf of mosque. In this case, interestingly, Mutawalli is not filed the case on behalf of the mosque. The question was put forth by one of the judges sitting in Supreme Court. If Mutawalli has not filed the case, what is your case? Then they were shocked. Even the court was shocked to notice that this case was not instituted by the Mutawalli, because we have established there was no regular prayer performed by the Muslims, and therefore there could be no Mutawalli. You see, the Mutawalli will be there only if it is a functioning mosque. We have projected the case, it is not a functioning mosque. They have abandoned this mosque because we were being worshipping there when there is a place, idol is there, and the entire premises, if you find it, we have established before the court, there is a Varaha Murti was there, and Jai Vijay was there in the premises, which they called as a mosque. In the mosque you cannot find the Jai and Vijay. Jai and Vijay are watchmen to the god Vishnu. So they were there. We established even before destruction, we have established the Jai and Vijay were there, and Varaha Murti was there. All these points we have established. That is why they find it very difficult to prove that that is a mosque.
पुरातत्व विभाग के आर्कियोलॉजिकल एविडेंसेस कुछ थे, कोर्ट ने कितना रिलाई किया जब सारे केस को कोर्ट ने कंसीडर किया और फाइनल वर्डिक्ट दिया था? तो एक तो बिलीफ की बात थी, ये बिलीफ नहीं था, हमने बाकी चीज़ें भी कही कि यहाँ था और क्या सर्कमस्टांसेस थे उनके बेसिस पे. इन एविडेंसेस को कितना कोर्ट ने कंसीडर किया जो आर्कियोलॉजी ने दिए थे?
नो, कोर्ट, आई वुड से दैट कोर्ट हैज नॉट फुल्ली और इन फैक्ट relied upon the archaeological evidence. Archaeological evidence is one of the facet in this case, because we have been telling this, there was a temple existing and that temple was destroyed. Then the court put a question, because the court put a question whether there was a temple and that temple was destroyed. That was the question put. So in order to establish that whether there was a temple, the archaeological help was needed. Therefore the archaeology evidence was produced that there was a massive temple. But the Supreme Court, but in the High Court relied upon the archaeological evidence, and it supported the case of the plaintiff to the Hindus. But in the Supreme Court did not fully rely upon, I would say that in the Supreme Court the archaeological evidence was not at all relied upon. The archaeological evidence was accepted, but that was not relied upon, because there is no necessity for the Hindus to establish through archaeological evidence that there was a temple, because it is sufficient for us to establish that since time immemorial we have been worshipping that place. Then interestingly a question was put forth from the court, if there is no deity is there, can it be called as a temple? Then we have cited so many examples from Tamil Nadu, that in Tamil Nadu, in Chidambaram, there is a place where the deity will not be there, because God is in the shape of Arupam, that is formless, and God is also a Rupam, that is formless. Then God is in the shape of form and formless, Arupam. So therefore it is like that, Sivalinga is form and formless. So we all established all these things. There can be a temple even without idol. I tell you another instant. We relied upon one judgment which is from London. one person smuggled Nadaraja Murti from Tamil Nadu and he sold it in London. In London they investigated this Nadaraja Murti belongs to some temple in India, particularly in southern India. And in Indian government filed a suit in London court and they established that this idol, this Nadaraja Murti belongs to me. They put a question, which temple it belongs to you, which temple this deity belongs to you. We find here there is no temple existing. Then they put a question, can there be a idol without a temple? Then we established once there was a temple, it is always a temple. There can be a temple without idol. Because once there was a temple, now the temple is not there. It doesn't mean the temple is not at all there. So in this case we told very clearly to the court and we established once the temple, it is an always a temple.
वंडरफुल। एक आखिरी सवाल, ये केस आपके फेवर में आया, श्री राम के फेवर में आया, उनको उनका अधिकार वापस मिला है। इससे देश में जो बाकी इस तरह के मामले चलते हैं, छोटे या बड़े, जो लाइमलाइट में होते या नहीं भी होते, कोई लाइन हमको मिलती है कि उन पे असर पड़ेगा? Would this be quoted to those cases?
No, we can't say that because every case has its own facts.
Correct.
And its own law. But we can tell one thing, this case is proved to the world that it is constitutionalism is prevailing in India. In India, everything can be done only through constitution. The interesting part is the temple was destroyed by Babur, and next to him the British government came, and next to the British government we the Indian government has come. So this case is travelled only through legalistic manner. The person, the earliest king who has done injustice to his own citizens has been remedied through court of law and through constitution. It can be done only, I believe this is the only case in the entire world where through constitution the previous wrong has been remedied.
बहुत सुंदर योगेश्वरन जी, मुझे लगता है कि आपका कोर्ट में जो चला वो शायद आने वाले इतिहास तो जो है बनेगा, आने वाली पीढ़ी को वो बहुत कुछ सिखाएगा। वो सिर्फ विधि क्षेत्र के होंगे ऐसा नहीं है, हम सबको भी जो सामान्य लोग हैं बहुत कुछ सिखाएगा। बहुत बहुत धन्यवाद योगेश्वरन जी, थैंक यू।